So hello everyone. Today I am going to discuss about Unit 1 of Business Law. It is my college subject, which I found very interesting. That is one of the major reason why I thought why not to share this on you with you guys. So without any further delay, let's directly jump into our subject. I hope my screen is visible to you and I'm clear with my audio. So here is the syllabus. As you can see, Unit 1 says that the Indian Contract Act 1872. So you can imagine there was a time when we just promise and that's it. But there has to be some legal force that has to be binding all of these things because there has to be some accountability. If someone is promised something, he or she should not be take it lightly. So that is basically to solve that complex problem, this act is come into place. So we are going to discuss about it step by step. So don't worry about anything. I get all of these things sorted. But before starting this unit one, chapter one, I would say think of it like if you are going to step into a corporate world. Okay. So this are going to already been existed in that corporate world. So you should have this type of knowledge. If so, take it in that manner that you are should be familiar with all of these terms very well. So when after 2 years or 1 year down the line, when you step into your corporate or start your corporate journey, that you won't feel hesitate when someone uses this type of terms or something. You should be very confident that you know you have very fundamental strong principles. So let's start. The first topic here is general principle of contract. So there are certain principles, but first, before starting this topic one, why this topic exists, why it is existed? Because human made thousands of promises every day, and and the law needed a clear rule book to decide which promises court should enforce. As it is mentioned very clearly that we as a humans made thousands of promises. So as the entitled body should have something in his or basically in his hand that they can enforce that particular promise. So that is why a general principle of contract has been existed. In simple words, I would say a contract is an agreement, but not all agreement is a contract. You can say that promise, the more deeper version of promise is, I would say, agreement, and the more deeper version of agreement is contract. Basically, if you don't understand it, try to imagine a big diagram. Like in Maharashtra, there is a city called Mumbai. In Mumbai, there is a place called Thane, or let's say Bandra. So you can understand that basically I'm just narrowing it down. Not all Bandra is Mumbai. Not all Mumbai is Maharashtra. Similarly, there is the one big circle which we call as promises. There are thousands of promises which we made on daily basis, but there are certain agreements of it. But in that agreement, there is only limited number of contracts that has been existed by the and obviously I would say enforced by the law. We will study about it, but just make these three things very clear in your mind: promises, agreement, and then contract. And this contract act, just we are going to study the contract, the Indian Contract Act 1872. Just remember this date. I would say the way I remembered it is like 18 into 4 is 72. 18 fours are 72. So I just imagine it like that. Okay, so a contract is an agreement enforceable by law. Section 2. Every contract is an agreement, but every agreement is not a contract, as I mentioned. There are four important elements that I think that you should remember. As I already mentioned, promise. One person offers, another accepts, that is a promise. Agreement, promise plus consideration, something in return. For example, if I am promising you something, like for example, I am uh, making some promise, then I will get something in return as well, or I will uh, give you something in return. Basically, it has to be a two-way street, not a one-way street. Then contract. How basically agreement, when we added agreement with the legal enforceability, then it implies it as a contract. So the possible question from this topic, I would say, what is contract and how it is distinguished between agreement and contract. That might one of the question which I feel that can be asked from this topic. As you can read it afterwards, but currently my focus is to explain you the topics. In the topic two is the classification of contract. As you now you are we and you are on the same page that contracts are necessary. We read about promises, agreement, and contract, and we also understand how it is different from each other and the need of contracts. We understand all of these things. Now there are different types of contracts. So on the basis of what we are going to classify the contract on the basis of four parameters. The first parameters on the basis of validity, second on the basis of performance, third on the basis of formation, and the fourth is on liability. Just uh, think it in this way. On the basis of validity, if the contracts end and both the party fulfills their promise, then it is come under valid. The under valid under validity it comes in valid. If like I would say here it is mentioned a contract that was valid but ceases to be enforceable by law due to some events. For example, you know that Russia and Ukraine has started the war, I would say 2 to 3 years back. So maybe there was an agreement between one of the party in Ukraine and one of the party in Russia, but due to this war, which just sudden came in their face, so due to that, the contract has been violated and it comes under void contract. Okay, so you can see the it is written a contract that was valid when made but ceases to be enforceable by law only later due to some event and change in circumstances. It becomes dead later. It was once alive but no longer has legal forces. Example, it agrees to export goods to a country but war breaks out, contracts become void. Then the third one is voidable contract. If let's say there are two parties and one party think that at middle that party think that something shady or they doesn't want it to continue in between, so they can voided that contract. So that comes under voidable contract. Basically, the legal body has give that right to that party. A contract that is valid and enforceable unless the aggrieved party who consent wasn't free chooses to cancel it. It's valid until avoided. The injured party decides whether to continue or cancel. It tricks A tricks B into signing a contract by fraud. We can cancel it, making it a voidable. Just see what I did was basically understand it with an example. Like void example, I related with the war. That valid example is like, okay, I made a deal, both parties finish it with a good terms. That's a valid contract. War and the voidable is like when one party has been tricked by the other party and when one party wanted to get out of that contract that so he can the party can use a voidable contract. The last one, as the name suggests by itself, is an illegal contract, a contract that involves an unlawful act and is forbidden by law from the beginning. It's void from the start and punishable by law. It cannot be enforced under any condition. A and B agrees to smuggle goods across the border. Some contract is illegal and void. So basically now you understand what are the subtypes of validity. So basic validity you can also consider as a time duration. Okay. Then the second is basis on performance. Executed, or I would say executory, to be done. It is simple as the name suggests. The third is basis on formation. Like this, there are certain contracts that has been spoken or written, and there are certain contracts that has been implied or by action. The next one is based on liability. Mm, Like in this type of contracts, both the parties are liable to that contract. Basically, a two-way promise in the bilateral, and there is also subtype where there is only one promise. We can call it as a unilateral. So now, basically, this is our topic two. So what we understand till now, the first we understand there are why basically contract is necessary. The what are the three things like promises, agreement, and then contract, how it is different from each other. Then there are different types of contracts. So there are four basic parameters on which we can classify contract. The first one is validity. On the second is on the basis of performance, like it is done. So we can consider it as an executed or executory, which is to be done in future. And the third one is on the basis of formation, like for example, spoken or written or implied basically. The second one is, and the last one is on the basis of liability. It's a bilateral or a unilateral. So I hope this is you made it very clear in your mind. Now we are going to start with the third topic. You can see this diagrammatic representation. You can just imagine this in your mind, and all of the thing which we just revised, which we just learned, you just revised it on your mind by looking at this one single picture. Now moving to the third topic, what are the see? We understand there are classification of contracts, but after let's say we pick if one particular contract, let's say we pick on the basis of performance, we pick executory, let's say. But there are certain things which we need to follow before going on any contract. There are six basic elements that we have to fulfill before publishing or before launching any contract. So, what are those six elements? The first one is offer and acceptance, which means one party makes an offer and the other parties accepts it freely and clearly. It's a very basic principle. I would say basic element. The second is free consent. Both parties agree willingly without fraud or undue influence. So, offer and acceptance, free consent. See, consent is very important. And the third is competent parties. Both the parties should be 18 plus and has their legally capable, not minors. Their mind is like a sound minded person. So, these three are very basics. Offer and acceptance, both the parties should follow. The second is free consent. The consent is very mandatory. The third is competent parties. The parties should be competent enough. The fourth one is lawful consideration. There must be something value exchanged. For example, there should not be a one-way street. Let's say someone is giving me goods, but I'm not giving anything in return. So that is like I'm exploiting the other person. That should not be the case here. There should be a two-way street. That is what mentioned in lawful consideration. There must be something value exchanged has to be taken place. The next is lawful object. The purpose of the contract not be illegal. The object which we are exchanging or something, the services, has to be lawful under the criteria of lawful, not expressly declared void. The agreement should not be one the law specifically prohibits. Okay. So these are the six elements that we should keep in our mind before launching or before publishing or before starting any contract. Okay, so you can also see this image. These are the first of all offer. Both the parties should agree. Free consent should not be under any influence. The third is competent parties should be sound-minded and adult. Lawful consideration. It should be something in written as well. Lawful object. There should be no illegal objects in taken place. Not declared void. Yes, I agree with you that 5 and 6 are mostly overlapping each other. But yeah, that is as per the book. So I made it as it is. So now moving to the next thing, the topic 4. Before starting topic 4, let's quickly revise what we have learned. We start why it is necessary a contract existed. Basically, we understand that there are a lot of promises. So to make it clear or enforced by entitled body, there should be something known as agreement. To make it much more clearer, we made it a contract, and we know that the three difference between each other, how it is different from the other. The other in topic 2, we discuss about I would say the types of the what are the classification of contracts on the basis of I would say validity, on the basis of performance, on the basis of liability, and on the basis of what is the next one? What on the basis of formation? Yes, on the basis of formation. On the basis of formation. In topic 3, we discussed about uh, what are the top six elements that we should check before starting with any contract. The first is, as I remember, it is free. Both the parties should be agreed, offer and acceptance. The second is consent. The third is lawful object. The fourth is um, competent parties and non-declared void. Now, starting with the fourth topic, which says performance and discharge of contract. So basically, the contracts are not for life. There is a certain duration of every contract. So what happened after when a contract ends? So there are four ways how the basically the mode of discharge of any contract. The first is by performance. When both parties completed their promise, they both happily ends the contract. The second is by mutual agreement. If in between both the parties think that this agreement won't work, they sit on the table and decides that we should uh, ex- made it closed before it's so that is by mutual agreement we called it as a mode of discharge. The third is uh, by impossibility of performance. Is it is basically when unforeseen events like flood or war, as I mentioned, something that sort happened. So at that point, the mode of discharge here is by impossibility of performance because they are not being, it is type of impossible to perform the contract, things like that. The last one is by breach of contract. Okay, so when one of the party, I would say, is not being able to fulfill his promise, as it is mentioned, like when one party fails to perform their promise, giving the other a right to end the contract. So now that is our topic 4. Now this is the image. You can see the image as well. Now moving to the topic 5th, it is related to the breach of contract only. So there are certain ways, I would say, where the breach of contracts happen. The first is actual breach, and the second one is anticipatory breach. Actual breach is when at the due date or after the due date ends, the other party is not being able to fulfill his promise on the due date. So that comes under actual breach. But let's say before the due date, in between only a party comes and says that I'm not going to be fulfill the declare promise. So that is type of anticipatory breach. When a party declares before the due date that they won't perform, that is an anticipatory breach. Remedies for breach. So there are three type of remedies that the other party will has to give to that party. The first is damage, monetary compensation for the loss caused due to breach, specific performance, any specific action that has been taken by the by the legal body. The third is injunction. Court might say that you can't perform your job from now because you are not being able to fulfilling your promises. So that is something one of the case. Now moving to the sixth topic, spatial contract. There are certain spatial contracts as well, and I am sure that most of you guys are aware about it. The first is there are only four types of spatial. The first one is contract of indemnity. Don't go by the name or the terms. It is nothing but just a one party promises to protect another party loss. It is like an insurance company, like life insurance, car insurance, health insurance, or something. Contract of indemnity. It is a very special contract, or I would say very popular as well. The contract of guarantee. When it normally happened in bank loan, it is type of when one person takes a guarantee to other person. If he or she is unable to pay, then the guarantor will pay on that on their behalf. This is what we call as contract of guarantee. The third is contract of bailment. When I, let's say for example, when one party give its goods or services to other party for a certain time or period, that is come under a contract of bailment. The next one is contract of agency. One person act on behalf of another to create a legal obligation. Example, an influencer or an ad agency singing deals for a brand. It's like an agency. Okay, so these are the special contracts. So yeah, that is how this chapter ends. But let's just quickly revise it in the chapter. What we learned is first we learned about why contract is necessary because there are a lot of promises out here in the real world. So to break it down, and there has to be some entitled body who we can go if the promises are not being fulfilled. So we understand that the difference between promises, agreement, and um, I would say contract. Promises are nothing but when one person agrees to deliver something to another, and the both party agrees. The agreement is, I would say, um, let's see what it is. I'm not getting the exact word. Agreement is like a promise plus consideration. Yeah, something in return. That is an agreement. When an agreement, what is, I would say, what is contract? Contract is equal to agreement plus a lawful enforcement. Then I would call it as a contract. Then we understand about what are the classification, what are types of contract. So there are basically four types on the basis of validity, on the basis of performance, on the basis of formation, on the basis of liability. So starting with the first one on the basis of validity, there are four subtypes. Valid, like both the parties agrees and fulfills the promise on time. The second is void, and third is voidable, and the fourth is illegal. In void, basically, when due to war or some unimaginary action has taken place, flood, war, or something, the contract is unable to fulfill or to continue, I would say. The voidable contract is when the other one of the party has the right to end the contract, has the right to end the contract. That is come under voidable. And illegal contract, the name suggests, basically uh, any illegal products are being smuggled or something. So that is come under illegal contract. So the second, I would say, on the basis of performance, there are only two subtypes. Execute execution is it is to be done, or the second one is executatory, to be done. It is like pending. or have the time to be done. There is a time. Based on the formation, there are further two types, spoken or written, and the second one is enforced by or by action implied. The third one is on the basis of liability. There are bilateral or unilateral. Unilateral is when there is only one person is liable, one promise exists, and the second one is bilateral when the both the parties are promising something in that contract. Then in the topic three, we understand what are the top six elements that are required before starting with any contract. The top six elements, I would say, the first one is uh, both the parties should be free and agrees first. Second is consent. The third is lawful object. The fourth is competent parties. Yes. Yeah. Then the lawful consideration. Yeah, I have to read this. I have to remember all these six things. The next topic I would say is performance and discharge of contract. So there is a time when contracts end. So first is like by performance when both parties agrees and closes the contract. The second is by mutual agreement, by impossibility of performance, by breach. Then further the breach has subtypes on the basis of actual and anticipatory breach. Then the remedies would be damage, any action by the court, specific performance. Then the third is injunction. Then the special contracts like the indemnity, contract of indemnity, contract of guarantee, contract of bailment, contract of agency. These are top special contracts. And yeah, that's it. That is all about this. I hope you like this video. I can somehow been able to add the value to this way. If I am able to add some value, then please do like this video, because that is only the way I will be able to understand that yes, I can add value. I did add the value, and I'm trying. I know that there are certain ways that I'm making my communication is not that well, but I think that I'm just trying my level best, and I would say we all should try, because we don't know where we will go. But if we don't try now, it will take time, definitely. In a year, let's say for example, if for 1 year I try speaking this thing in and try to add value to your life in which way possible, then I feel I will be as better person, in terms of there are a lot of skills that has been inbuilt in me unknowingly, I would say, because I follow this type of habits. I wanted you to do the same. So without any much more delay, let's end this thing. And I'm going to bring the second unit quickly, as quickly as I can. So till that time, enjoy and have fun. Thank you.